5 seconds to go. Start. The order of detention is dated 12th of November, 2021. Stop. There is no explanation worth the name why it took almost 5 months for the detaining authority to pass the order of preventive detention. Stop. Para. There is indeed a plethora of authorities explaining the purpose and the avowed object of preventive detention in express and explicit language. Stop. We think that all those decisions of this court on this aspect need not be recapitulated and recited. Stop. But it would suffice to refer to the decision of this court in Ashok Kumar versus Delhi Administration and others, within bracket 1982 to SCC 403, wherein the following observation is made, para. Preventive detention is devised to afford protection to society. Stop. The object is not to punish a man for having done something but to intercept before he does it and to prevent him from doing. Stop. Para. In view of the above object of the preventive detention, it becomes very imperative on the part of the detaining authority as well as the executing authorities to remain vigilant and keep their eyes skinned, but not to turn a blind eye in passing the detention order at the earliest from the date of the proposal and executing the detention order, because any indifferent attitude on the part of the detaining authority or executing authority would defeat the very purpose of the preventive action and turn the detention order as a dead letter and frustrate the entire proceedings. Stop. Para. The adverse effect of delay in arresting a detainee has been examined by this court in a series of decisions, and this court has laid down the rule in clear terms that an unreasonable and unexplained delay in securing a detainee and detaining him vitiates the detention order. Stop. In the decisions we shall refer hereinafter, there was a delay in arresting the detainee after the date of passing of the order of detention. Stop. However, the same principles would apply even in the case of delay in passing the order of detention from the date of the proposal. Stop. The common underlying principle in both situations would be the live and proximate link between the grounds of detention and the avowed purpose of detention. Stop. Para. In S.K. Nijamuddin versus State of West Bengal, within bracket 1975, 3 SCC 395, this court, while examining the necessity of securing the arrest of the detainee immediately after the order of detention, has held thus, para. It would be reasonable to assume that if the district magistrate was really and genuinely satisfied after proper application of mind to the materials before him that it was necessary to detain the petitioner with a view to preventing him from acting in a prejudicial manner, he would have acted with greater promptitude in securing the arrest of the petitioner immediately after the making of the order of detention, and the petitioner would not have been allowed to remain at large for such a long period of time to carry on his nefarious activities. Stop.